Appearing in the appeal, Owens and Owens.
Yes, Mr. Marshall.
My ladies, my lords, may it please you, as you know, in this matter I appear on behalf of the appellant wife, together with my learned friends Mr. Jarmain and Miss Benson. Mr. Dyer, Queen's Counsel, and Mr. Dunlop appear on behalf of the respondent husband, and Mr. Turner and Mr. Nagpal have, of course, been instructed to make written submissions on behalf of Resolution, who were given permission to intervene. Mr. Turner's role is entirely silent, and as you will readily appreciate from Mr. Turner, that has caused him some greater anxiety than even my own in having to open this matter to the court. In addition to the various bundles that we have lodged, I hope the court has received in a supplemental bundle a copy of a case called Jameson, to which we will refer briefly. We've placed on your desks, in addition, now a paginated index to the essential documents. The copy that appeared in the bundle was not, with my apologies, originally paginated, and I thought it might assist you to have it. And in addition, we've also placed on your desks a schedule which we will invite you to consider when you consider, in relation to the objective-subjective test, the analogy which we have sought to draw in our documents with self-defence and to what extent weight should be given to subjective perceptions in the way that we suggest is appropriate when considering section 1.2b. You don't have in your bundles the resolution survey to which reference is made in Mr. Turner's document. There was no agreement in relation to that, and so it hasn't been lodged. Could I just say, by reference to Mr. Turner and Mr. Nagbal's written case, they deal at paragraphs 71 to 125 with issues in relation to the European Convention of Human Rights, and that's memory stick page 159 following. I don't propose, given that it didn't figure in our grounds of appeal and so no leave was given, to speak to that document. It may be I will seek to respond to any points that my learned friend Mr. Dyer makes. Could I simply say that we respectfully adopt what is said in the written case to the extent that it is argued that Article 8 is engaged, and to the extent that the court concludes that our proposed interpretation of section 1.2b is straining at the edges of the terms of the statute, we would say the court is entitled, indeed required, to read down the text to try to ensure that it does not go across Article 8 in the way that my learned friends Mr. Turner and Mr. Nagpal have outlined. Can I just say, in terms of opening, as it were, you have two very full cases. You have our written case, and you have a similarly long written case from Resolution. And so I don't seek or intend to stick slavishly to that. I appreciate that the members of the court will have read it. I propose simply, in the time available, to seek to persuade you that what we set out in our document would amount only to a modest shift of focus in the interpretation of section 1.2b. We say, as you will have read, that it's appropriate to place greater emphasis on the subjective, i.e. actual impact of whatever behaviour the court has to consider when considering whether it is reasonable to expect the petitioner to continue to live with the respondent. That, of course, is not to the exclusion of everything else, but we say that it fits neatly and appropriately into the balancing exercise that must be undertaken between the subjective objective test as the authorities have set it out. Of course, we say that the petitioner's subjective beliefs and concerns, the impact that it's had upon her, is not determinative. We are aware, of course, of the observations in the case of Pheasant and Pheasant, upon which my learned friends for the respondent rely, and we accept that it cannot be determinative, but we say it is consistent with the objective set out in the legislation when the law was changed in 1969, as replicated then into the Matrimonial Causes Act 1973. We say that it does not require this court to rewrite the statute. It certainly doesn't require this court to step over the constitutional boundary to which my learned friends refer in their note. And we say it would be a proper revision, modest shift of focus, having regard to modern social attitudes and expectations. I propose to look briefly at really three main topics in the time that I have available. The first is, and I'll deal with it briefly, the legislative objective and its context. Second, how the case law evolved, both initially after the legislation was passed and then subsequently during the early 1970s. I propose, as part of that second topic, to highlight some important areas that we say are still overlooked. And I refer in particular to the linguistic trap into which we respectfully submit the learned judge, His Honour Judge Tolson, fell when he determined this case. I propose to invite your lordships and your ladyships to sweep away some of the misconceptions that are apparent from the early case law. And that, I say, is consistent with what I've at least written down here, is the Boris Bus principle to which my Lord the President referred in his judgment when he talks about speaking legislation and how it's appropriate for it to be interpreted at different times, having regard to current social norms.
Is it a difference of interpretation, or is it a difference of application? I thought that several times during your written submissions, that you might have been talking about application evolving rather than interpretation evolving.
Yes. I think the difficulty at the moment is that in the early case law, as we shall see very briefly, there was a lingering embrace to the old approach. When the matrimonial offences were swept away, certainly in the old case law, as the court will have seen, for example, in the cases such as Ash, Pheasant and Cats, there was reference to matters which more appropriately fell within consideration of the old law and matrimonial offences, such as cruelty. And so there was reference to issues of gravity, whether the conduct or behaviour was sufficiently grave to satisfy the objective test by reference to the old law. Whether it's interpretation or application, we say the court is entitled to have regard in the way that Sir James Mumby suggested was appropriate to expectations of autonomy, equality, and the like. And we've postulated some, or we've given some examples of the way in which within this field courts have updated, as it were, the approach which has been adopted to legislation which on its face requires interpretation and or application from time to time. And I'm thinking of such cases as White, Miller, MacLeod, and some such cases. One of our complaints is that although the President in the Court of Appeal identified the need to have regard to current social attitudes and trends and expectations, in fact, nowhere is that evident in the trial judge's approach, or indeed in the Court of Appeal's endorsement by dismissing the appeal against his judgment. It's postulated as a relevant factor, but it's very difficult in my submission to see anywhere where in fact regard is had to what might be thought to be a more modern approach, but whether by way of application or interpretation. Can I start with as it were, some basic findings that the trial judge made, and these are to be found in the judgment in Core Bundle 1, respectively paragraphs 2 and paragraph 4, memory stick pages 215 and 216. The learned judge found as a fact, as you will recall, that the marriage had broken down. He found as a fact that it was the case that my client was not able to go on living with the husband. And he found as a fact that the husband was deluding himself in thinking there might be some reconciliation. Those findings were endorsed as entirely appropriate, as one would expect, in the Court of Appeal. As you will know, at the time of the trial, before His Honour Judge Tolson, the parties had then been separated already for some 11 months, since February 2015. But nevertheless, the learned judge dismissed the petition. In addition to the core findings that the learned judge made, in March of 2015, Mr. Owens had indicated that he proposed a petition for divorce based upon my client's adultery. And that was set out in my client's statement, and nowhere was it contradicted or was she challenged in evidence. Of course, he wasn't able to rely upon my client's admitted adultery because, in accordance with Section 2, subsection 1 of the Matrimonial Causes Act, having continued to live with Mrs. Owens for more than 6 months, he was debarred from being able to rely upon it. And of course, he became aware of her adultery in August of 2013. In addition, in the course of cross-examination, he indicated and agreed with me that when he received the first letter from those who instruct me in April of 2015, indicating that Mrs. Owens intended a petition for divorce, he still believed that her affair was continuing. And the reference to that is Core Bundle 2, memory stick, page 440. But as I've indicated, in spite of all of that, the learned judge dismissed the petition on the basis that he was not satisfied that Mr. Owens had behaved in such a way that it was not reasonable for my client to continue to live with him. In our document at page 97, memory stick 97, forgive me, it's paragraph 76, we've set out, we've collected from the various documents, her statement and the transcript, all of the occasions upon which Mrs. Owens professed her profound and enduring unhappiness and the impact and effect that she said the instances of behaviour to which she had referred in her amended petition had had upon her. Although I accept that in his judgment the learned judge made a blanket finding of fact that my client had exaggerated or taken those particulars out of context, nowhere is any reference made to any of these instances of Mrs. Owens setting out her unhappiness and the embarrassment and the loneliness and her feelings as a result of the conduct. And she wasn't challenged about any of that either. And so we say it is doubly surprising in many ways. I think in the court below we used the word perverse, that the learned judge nevertheless dismissed the petition. And we do say that he fell fairly and squarely, as I've suggested, into the linguistic trap at all stages, both during the evidence and indeed in his judgment. His reference is to unreasonable behaviour. And his findings, as you will recall, again a blanket and not specific allegation by allegation finding, is that all of her complaints were minor altercations of the sort to be expected within a marriage. And we say, quite apart from falling into the linguistic trap, the learned judge simply got the objective or subjective objective balance wrong. He had no regard to the subjective impact upon Mrs. Owens, and when he considered the statutory question, as it were, was it reasonable to expect her to continue to live with Mr. Owens, he reintroduced, as it were, issues of gravity, blame, fault, which the authorities are quite clear are not relevant when the court considers the behaviour which is relied upon within the petition. This case is not about no-fault divorce. We entirely accept that in the manner in which no-fault divorce is properly understood, this court cannot re-legislate or rewrite the statute in order to introduce that which was attempted as long ago as 1996. And indeed, in 2014, as the court is aware, Part 2 of the Family Law Act 1996 was simply repealed. It was a very different statute to the bill which was originally proposed by the Law Commission in 1990, and we'll come to that briefly in a moment. It's important, or it's at least relevant, to have regard to the fact that the statute that was enacted into law in 1996 had its origins as long ago as 1988, so some 8 years earlier. The consultation document issued by the Law Commission, Facing the Future, to which a substantial response was received, and we've included the relevant parts of the Law Commission 1990 report in Volume 6 of the Authorities Bundle, resulted in the further report and then the enacting into law in 1996 of, as I've said, a very different beast, as it were, to that which was proposed by the Law Commission.
Well, you could say beast. I couldn't possibly agree with you.
Well, I have some vague recollection at the time, mindful of the fact it wasn't then actually in force, of struggling to comprehend what process had to be gone through before, in fact, the more direct and less convoluted process.
We don't have to consider proposals for reform of the law because that's not what we're about.
I entirely agree.
We are about the proper interpretation and application of Section 1.2b.
It's tempting, perhaps, to assume, given that 99% of divorce petitions now pass through the special procedure mechanism, that really these sort of cases don't greatly matter. The figures are variously set out in the papers before you. For your reference, in the President's judgment in the Court of Appeal, memory stick 211, and we've also included in the bundle the references to the quarterly figures and the Nuffield figures. Of relevance for our purposes is that of the approximately 110 or 114,000 petitions that were filed in either 2017 or 2016, behaviour and adultery are far and away the grounds most relied upon by both parties, i.e. petitioners, whether they be men or women. The Nuffield figures, which is at volume 6, memory stick 1900, suggests that as much as 60% of such petitions rely upon adultery and or behaviour, and probably behaviour and or adultery in terms of quantity. And I think that broadly accords with my Lady Hale's observations in a recent lecture in Bristol, where it was suggested about 56% of such petitions rely on adultery or behaviour. The President, in his judgment, extracts figures that are not actually published or I think formally kept, as it were, indicating that, and this is memory stick page 211, indicating that of the circa 114,000 petitions, notice of intention to defend was lodged in 2,600 of them, and answers filed in only 760, and the number of fully contested suits was suggested to be a mere handful. But of course, the concern which the President expressed in paragraph 94 of his judgment at memory stick page 209 about the hypocrisy and intellectual dishonesty and the collusion which is recognised now to be a factor of primarily the special procedure process through which 99% of all petitions pass, was a real cause for concern. We respectfully submit that the law risks falling into disrepute if the legislation, on the one hand, presumes to require, in the way that the learned judge interpreted it, behaviour which is of a much higher standard to satisfy the objective part of the statutory test, where in fact, anecdotally, and indeed the Nuffield Foundation and indeed the Law Commission in 1990 through its own inspection of files suggested that petitions going through the undefended process were at a very low level indeed, or very low threshold.
These statistics suggest, do they, that married couples whose marriage breaks up want to get divorced immediately. They're not prepared to wait 2 years and consent. They want to do it immediately.
My Lord, yes. And indeed, the contrast between the 56 or the 60% of petitions relying on adultery or behaviour contrasts with Scotland, whereas my Lord may know that there is, in a sense, both no fault and fault-based divorce to use the vernacular for a moment. So
Yes.
there's
That's a linguistic trap, isn't it?
it is, and I use it only for shorthand, and I'm very conscious of the
We
fact
use it
that
all the time, but we shouldn't.
my learned friend Mr. Dyer was able to find an occasion in the transcript where I fell into the trap of using the words unreasonable behaviour, but then perhaps we all do from time to time. Certainly, the government seems to use it, as does the Office of National Statistics. But, my Lord, yes, 6% in Scotland, because the periods for which one has to wait in Scotland are respectively 1 year with consent or 2 years without consent, as opposed to 2 years and 5 years. And
That's
so,
not necessarily the reason for the difference in Scotland. It may be part of the reason. But the research has indicated that there are other reasons as well,
yes,
and that reducing the periods south of the border to those that they are north of the border would not have the same effect
yes.
in reducing the reliance on
Yes.
A and B, shall we call them.
Yes, I think there is. I think it's suggested that there is a mindset when
It's got to do with procedures as well.
yes,
They haven't had the special procedure in Scotland.
no, well, quite.
So, but does any of this help us?
Well, it does in my submission, because the court isn't, as it were, only having to have regard to the handful or so of contested petitions. It has to have regard to the 99% of petitions that go through the special procedure, in the way in which Sir James Mumby highlighted the hypocrisy and lack of intellectual
But it might not be hypocritical. It might be entirely proper interpretation of the statute.
It might well be, and indeed it's our case, in our written case, that if the law is properly interpreted in the way in which we suggest, then indeed the President is wrong in castigating the process of being either hypocritical or dishonest. But of course, it's at the moment, the hypocrisy and the intellectual dishonesty, as it were, is the message that has gone out and which is causing concern. In amongst all of this, of course, there are two individuals. It's easy to lose sight of them, including perhaps even in this courtroom. Your Ladyship knows that they are now respectively aged 68, my client, and 80, Mr. Owens. They separated, and I'll deal with this very quickly, in February of 2015, after what on any basis was a very long marriage. Before that, in June of 2012, Mrs. Owens had consulted those who instruct me, and a draft divorce petition was sent, anodyne in its terms, in accordance with both the Law Society and Resolution's good practice, which is set out in the President's judgment. But it wasn't pursued. But as part of that draft petition, Mrs. Owens in June and December of 2012, when Payne Hicks Beach wrote, indicated that she had been very unhappy for very many years. She entered into a brief relationship, as you know, between November 2012 and August of 2013. Mr. Owens became aware of it in 2013 when it came to an end. I've indicated already that he told the Learned Judge he thought it was ongoing. The reference to that is Core Bundle 1 at Memory Stick 216, paragraph 4. And the judge found, he accepted that my client was telling the truth when she said it had ended in August 2013. That's Core Bundle, paragraph 6, Memory Stick 217. I've indicated already that when the matter came before the judge, the parties had been separated for 11 months, and so they could not at that stage rely upon 2 years separation and consent, assuming that consent would have been forthcoming. By the date of the hearing in the Court of Appeal in February of 2016, they'd been separated for 2 years and 4 days. And so...
17.
I beg your pardon, my lord. I can't... Time has flown or time has dragged, but I'm sorry, 2017. By that stage, they could have divorced on the basis of 2 years separation plus consent, but Mr. Owens was not prepared to do that and to agree. Effectively, my client now faces the prospect of having to wait until February 2020, by which time the parties will have been separated for 5 years. It's tempting to think that that's only another 2 years, and so is that a great hardship for her to bear? But she would wish the court to be aware that her inability to leave what is now a loveless marriage is a daily tragedy for her, and it is to continue for another 2 years. Can I move now to the sea change of approach in the Divorce Reform Act 1969, which ultimately found its way in identical terms, although different section numbers, to the Matrimonial Causes Act 1973. It's in Authorities Volume 1, right at the front at page 490 in memory stick, and it indicates that after the commencement of this Act, the sole ground on which a petition for divorce may be presented to the court by either party to a marriage shall be that the marriage has broken down. The 1973 Act is in slightly different terms, but the 1969 Act was, in a sense, declaratory because of the agreed approach between the Law Commission and the Archbishop of Canterbury's working group that irretrievable breakdown of marriage should be the sole ground. This legislation swept away, as the court is aware, the old matrimonial offences. There is a residue, of course, of some of them in terms of adultery, in terms of desertion. But
Well, the only one that remains unchanged is desertion,
indeed it is.
which is never used.
No, although I think it was suggested somewhere that with the proliferation of litigants in person,
Yes.
desertion seems to be enjoying something of a restoration, as it were.
But neither A or B remained as they had been beforehand.
Indeed so. We've set out in our written case, and forgive me, I simply refer to it, as it were, to fix it in your minds, the memory stick, page 72. The process toward the enactment of the 1969 Act, the Law Commission report, field of choice, and putting asunder the Archbishop of Canterbury's working group. And there was much common ground. I suspect, to some extent, somewhat surprised at the time. That resulted, as we've set out, and I'm looking at paragraph 17 of our case on page 74, in Appendix 3 to the Law Commission's report, third annual report in July 1968, which proposed a draft bill. As we've set out, and this is going over the page to 75 at the top, at that stage, the equivalent of what is now section 12B, I beg your pardon, was cast in different terms, that the conduct of the respondent had been so intolerable that the petitioner could not reasonably be expected to continue or resume cohabitation.
Reading between the lines, what seems to have happened is actually a change of direction between the initial proposals putting asunder, which would have removed any list of grounds, and this proposal,
Yes.
And one infers that the change may have arisen from a debate in the House of Lords in November 1966.
I think that's right, because I think the bill was initially introduced as a private member's bill, and so there was a debate.
Yes, I mean, quite.
But the basic change was, as I remember, and will be corrected if I'm wrong, that the Archbishop's group had thought that there ought to be an inquest into every marriage to find out whether or not it had truly broken down. And that, of course, was regarded by the legal practitioners as being completely impracticable, because it would in practice have made it much more complicated and difficult and uncertain about obtaining a divorce, because, of course, in the olden days it had been comparatively simple to obtain a divorce, provided somebody was prepared to put their hands up to adultery.
Yes.
So that proposal was abandoned, and in exchange, the various matrimonial situations were inserted into it. That's my recollection of what took place.
Yes, indeed. I think there was effectively, as it were, a compromise and a trade-off, as it were.
Yes, and there were a lot of discussions.
Yes. We haven't included in the bundles, in what was perhaps a rather futile attempt to save some trees, the Law Commission report of 1968, or indeed putting 1966, or indeed...
It's very short.
Well, yes, or putting asunder.
Putting asunder is rather longer.
It is. It's an interesting read in pamphlet form. We can make those available if the court would wish to have them, and indeed Appendix 3 of the third annual report.
But the point you're making is that there was not intended to be any necessary connection between the situations and what the previous law had been.
Exactly so. And a good example of that, as it were, is the way in which the word intolerable, which brought with it all sorts of baggage, if I can put it colloquially, was simply then expunged from the 1969 legislation and indeed into 19...
Well, not from A.
I'm so sorry?
Not from A.
No.
Intolerable is in A.
No, it is. I'm confining my submissions to...
Yes, but we have to draw some conclusions, don't we, from the fact that the word intolerable is used in A,
Yes.
And unreasonable to expect is used in B.
Yes,
That must be deliberate, given the previous history.
I would accept that entirely, and of course the argument that is put is that issues of intolerability under 1.2a, adultery, are entirely subjective. It's futile to suppose a judge could tell a petitioner that he or she does not find it intolerable to continue to live with the respondent. The issue in 1.2b, the word reasonable, it introduces the objective test. It is not, and that's why I've said that far greater weight, perhaps significant weight, should be given to the subjective impact upon the petitioner. But I do accept there is an overarching objective assessment to be made. The point we make, forgive me, I'm possibly repeating it, is, and the danger is allowing issues of blame and fault and gravity to creep back in at the objective stage.
Well, I can see your point in relation to blame and fault, but does the same apply to gravity?
Well, the authorities, my lord, are pretty clear that gravity is immaterial. And I'm going to suggest, simply by reference to 3 of the early cases.
Well, I have to see what they understand gravity to mean.
Yes.
But I'll be grateful if you show me that.
Yes. Does your lordship want to look at that now? Or?
No, in your time.
I'm grateful. And so, if I can just, as it were, draw your attention to our paragraph 15 on page 73. You will see there set out, I don't propose to read it, but it's the penultimate paragraph of putting asunder about not a reward for marital virtue on the one side and a penalty for marital delinquency on the other, not a victory for one spouse and a reverse of the other. And then in field of choice at little 2, when regrettably a marriage has irretrievably broken down, to enable the empty legal shell to be destroyed with maximum fairness and the minimum bitterness, distress and humiliation, the law should make it possible to dissolve the legal tie once that has become irretrievably broken down. In fact, if the marriage is dead, the object of the law should be to afford it a decent burial. And that was, of course, accepted and relied upon in the case of Ash and Ash, one of the very early cases, as being the purpose of the new legislation. And so in our written case at page 76, we've set out what we say or suggest is clearly Parliament's intention at the time at which the 1969 Act was passed. We've cited the case of Grenfell. The court, of course, that's in a slightly different context. The purpose of Parliament was to ensure that where a marriage is irretrievably broken down, it should be dissolved as quickly and as painlessly as possible under the Act. And then we set out what we suggest are the other two bases, one of which, the third point, is the finding of fault was no longer to form any part of the law. Such an approach was henceforth to be avoided.
But by definition, it seems to me your little two can't quite be right. The language indicates that the facts which have to be established are not means to establishing a breakdown. They're thresholds or conditions, and they're not necessarily tied to the concept of breakdown, are they? They are conditions which may mean that some marriages which are broken down nonetheless survive.
Well, certainly some of the authorities talk about dead marriages and the fact that the marriage is dead and that there's no prospect of cohabitation does not often in itself justify the pronouncement of a decree. And so I accept, as it were, that within the terms of Section 1, the court can only make a finding of irretrievable breakdown if it is satisfied of one of the grounds. Yes. I accept that.
Yes. I mean, there are 5 gateways to the conclusion.
They are. I accept that. But there is, as you will be aware, in a sense, it raises, the authorities talk in some respects of raising a rebuttable presumption. If you can satisfy Section 1(2)b, there's a rebuttable presumption that the marriage has irretrievably broken down. The court then has to ask itself the question, having regard to all the circumstances, has it not broken down? Which is a slightly circuitous process, but in essence, one can imagine circumstances. For example, to take a hypothetical situation, parties might have been separated for 2 years, i.e. living separately for 2 years. They both consent, but the court is nevertheless satisfied that the marriage has not irretrievably broken down because the marriage has continued in a different way, albeit they are not living together.
These occasions must be rare.
I think they must, but I'm trying, in a sense, to make sense.
Vanishingly rare, I think.
Yes, we've tried to think of hypothetical situations that might, as it were, satisfy the process through which the court has to go. And I respectfully agree with you, Lordship, that such examples as we're able to imagine would seem rather fanciful. But there must be situations in which the court would not be so satisfied. The respondent says that our interpretation and the approach that we invite you to adopt would seek to change the law and that it would overstep the constitutional boundary. Our case, as you know, is that there should be much greater focus upon the subjective, i.e. actual impact of the behaviour relied upon the petitioner. That not least because the authorities make very clear that one is required to have regard to the subjective peculiarities, character, etc., of both parties. It would be, we respectfully submit, altogether surprising if the court paid no regard at all to the sort of impact, subjective impact, to which I referred in our note, which was set out in Mrs. Owens' evidence when considering whether it was reasonable to expect her to continue to live with the respondent. The answer that Maloney Friends give is by reference to the case of Pheasant, in which the judge, and we'll look at it very briefly, said, well, what of the respondent whose conduct is entirely reasonable, in inverted commas, save by the standards of this petitioner? He or she would have no prospect at all of defending the suit, because it would, and Maloney Friends take it a stage further, and they say it would be tantamount to allowing divorce upon unilateral demand. And the case of Pheasant is a rather factually peculiar case in which there was virtually no complaint raised by the petitioner husband, other than that the wife did not demonstrate the sort of affection that he required, and that, in increasingly hysterical terms, as the judge narrates, led the husband to say, I can't possibly live with her. It is not what I require in a marriage. And the judge said, well, you can't have that, because that's entirely focusing upon the petitioner, irrespective of whether there is any behaviour which might have given rise to the subjective impact to which the petitioner upon which the petitioner was relying.
What if the behaviour wasn't what I think you described as innocuous? I mean, supposing your spouse is 10 minutes late for every meeting. I mean, you might find that intolerable. Is that a ground for divorce?
But, my lord, it probably depends, is the answer. I'm so sorry?
Yes. It depends on what?
Well,
on my reaction to it? I mean, I think most people would say that's life. Some people are late, some people are punctual.
Well, that's, of course, exactly what the learned judge did say.
Yes, but I mean, are you saying that if I'm particularly sensitive to that sort of thing, then it entitles me to a divorce?
My lord, yes, that is our case, because if your lordship evidenced the level of distress and unhappiness persistently in the way that Mrs. Owens, for example, in our case, has set out, the court has to have regard, A, to your lordship's subjective sensitivities, and B, to the impact which that conduct has had upon you. I mean, I was...
There could be a point of view that says that's exactly an example of a situation where it's unfortunate that it isn't unreasonable behaviour that is the ground, because to be 10 minutes late for every single appointment throughout a marriage of some duration might be thought by most people to be unreasonable behaviour.
Yes, well, I would agree with that. I mean, we hadn't taken your lordship's example, but we did take, for example, and I appreciate you're not going to be persuaded by examples, but we took the example of smoking.
Yes.
Many people,
that's a
good
example,
would say, I cannot be married to somebody who smokes. The court may have, of course, to have regard to that. Was this somebody who smoked when you married them?
Yes.
Because then the court may simply say, well, I'm afraid that just doesn't...
Yes, it's probably a more realistic example than mine, because I don't know anyone who's 10 minutes late for every meeting.
I think I sometimes am, but not for everyone.
Not for everyone. No.
Sometimes it's 7 minutes, yes. But quite. But one could develop my scenario, as it were, perhaps more subtly, in the sense that if is it smoking in the garden? Is it smoking in the kitchen? Is it smoking in the bedroom? Is it smoking in bed? And once the court gets into value judgments like that, it becomes somewhat absurd. And the problem, in a sense, is if one introduces issues of gravity at the objective analysis stage, then one sets a threshold by which, frankly, there's almost no reference point, to take your lordship's point. Some people may find being 10 minutes late absolutely infuriating, living with it year after year after year. I know the objective, reasonably minded, right-thinking person tests assumes that the court has regard to the whole range of possibilities. But actually, one loses sight of the fact that the question is it reasonable to expect this petitioner to live with this respondent, not some hypothetical reasonable petitioner?
Would you look at other, since you say you look at all the context, would you look at other aspects and say, well, come on, this is a rather rigid behaviour. If you take that objection, maybe the solution would be to have some counselling.
You might do, and indeed in some of the earlier authorities, and I suspect one of the objectives identified by the Law Commission was indeed, not their words but mine, as it were, to sustain savable marriages rather than simply making it easier to get divorce. Yes, that would be an issue, but the court, on our analysis, would have to have regard, for example, to the genuineness of the subjective feelings and unhappiness and the impact that the behaviour has had. That would be a matter to which the court would properly have regard. And some of the cases, so for example, Pheasant and Pheasant, the judge was plainly unimpressed and attributed an entirely different cause to the husband's unhappiness. In fact, in that case, he said the wife had done all she could. But to draw in a point I was going to make slightly later on, in the case of Ash and Ash, for example, although Ash and Ash is still cited as one of the very early authorities, and indeed it's one of the authorities to which the President makes reference in his analysis of the case law, starting on memory stick page 190, so it's paragraph 28 of the judgment in the Court of Appeal. Ash and Ash contains, and I think we've set it out in our note, a most curious approach, we would say, in modern times, such as it's not unreasonable to expect the violent husband to live with the violent wife, the alcoholic wife with the alcoholic husband, the flirtatious wife with the flirtatious husband. In modern times, one would probably say they both have good grounds for divorce. But it would be most extraordinary indeed in our submission if that approach was to be taken now. There must come a point at which a violent petitioner is entitled to say, I am no longer prepared to remain living in a relationship that is habitually violent or habitually alcoholic or persistently flirtatious, for example.
And what if one of them is a lot more violent than the other?
Well, exactly so.
I mean, it leads one into all sorts of extraordinary...
Of course it does. I mean, in essence, one would have to wait until something really bad happens.
But those are very old cases, aren't there? Are there not authorities that are far more recent, Court of Appeal authorities that are relied on far more frequently? I'm thinking of O'Neill.
Yes, although it's interesting, for example, that Katz is still cited as authority in Raden. We've included the most recent...
Yes, I see that, yes.
Yes. Ash certainly has a pedigree, which perhaps some of the other passages in the judgment would not necessarily justify in modern times. But yet the answer is yes, and I was going to come on to the point that how the case law has evolved from the three cases of Ash, Pheasant and Katz where even after the passing into law of the 1969 Act, gravity was said still to be a relevant factor. And there then came a point, as you will be aware from our written case, in the case of Livingston Stallard, where Mr. Justice Dunn said, I'm not prepared to follow those old cases. Gravity is irrelevant. It is immaterial. And Livingston Stallard was then approved in O'Neill by Lord Justice Kearns and Roskill, and most recently in the case of Uffrey by Lord Justice May. All of them still rather old, although one would say that they've now been approved in Owens and Owens in the Court of Appeal, and it's no part of our case that those authorities are wrong. We simply say that the law is in something of a muddle because it's rather grown by like topsy.
Can you just, I mean, for my part, I think this follows on Lord Hodges' earlier question, but I think we may need to look at those authorities a little more than you have done, because I don't understand how gravity can at the moment be completely irrelevant. If we're looking at behaviour of such a nature or in such a way that somebody can't reasonably be expected to put up with it, surely a relevant starting point is to work out whether the behaviour is entirely gross or whether it's what in ordinary circumstances would be regarded as rather minor.
My Lord, it's not an irrelevant consideration because, as a matter of fact, of course, there will be many petitions in which grave and gross conduct is relied upon. Yes. And certainly the authorities say, when one asks...
I mean, if somebody's trying to murder you, that's rather different from somebody giving you a push on the arm.
Indeed so. What the approach... in essence, what the authorities say about that is that if the conduct is gross and very grave, that will provide a ready answer to the question, is it reasonable to expect the petitioner to continue to live with the respondent? I mean, that's a matter of common sense.
Yeah, well, I'm glad to hear it.
Quite. But the fact that the conduct is not grave or gross does not, unlike the old authorities, mean that it doesn't pass the threshold. And that, at risk of repeating myself, is where we say the trial judge fell into error.
Well, I suppose what you mean by, it may depend what you mean by gravity. I can see gross can be unfortunate, but in at least one case, I think Stephen's case, the judge speaks of the cumulative conduct being sufficiently serious.
Yes.
So it is looking at the nature of the conduct as well as the impact of that conduct on the particular spouse.
It is. I mean, I accept that when one reads through the authorities, to some extent, the citation of authority, both to which the President referred and indeed Raiden refers, endorsed by the President, is somewhat selective, by which I mean, actually, if one reads the cases in full, there are often observations, or one might say unguarded comments, that seem to reintroduce the very thing which the court has said is not relevant.
But are you saying that the comment that the cumulative conduct is sufficiently serious, that is a mistake, that's an irrelevance?
I say that no greater weight should attach to it, because if Stevens, Your Lordship is absolutely right, talks about cumulative conduct by reference to Raiden. I mean, in essence, it's something in Raiden which the Court of Appeal, which in Stevens was accepted. It's one of our complaints, in a sense, that a whole range, a whole raft, a whole number of minor acts of the sort that the judge rejected in our case, cumulatively, would amount to conduct which was sufficient, without any further qualification, as it were, to satisfy the test. If one starts talking about serious or grave or gross, then one starts, we respectfully submit, to reintroduce.
Well, certainly when the word gross is used, I would not quarrel with you on that point.
Yeah.
But if there is a test of sufficiently serious cumulative conduct. That seems to me to give some content to the objective element of 1.2b.
Yes, I mean the case on the case that we've handed up in the supplemental bundle of Jameson and Jameson, although it was a Scottish case which in essence turned on issues of pleading and practice.
It's a very famous Scottish case.
Indeed it is, my lord, and that's why we've put it in the bundle. But it rather neatly summarises what we say is an appropriate common sense approach to the issue of cumulative conduct.
Yes.
And it's at the bottom of page 535. Your Lordship may be familiar with it, where the learned judge, I mean, what in essence had happened, I think, is the case was struck out on a summary basis simply by looking at the pleadings, as it were.
That's what it's famous for.
Exactly.
Therefore, you'll have to refer me to this passage because I'm not familiar
Yes.
with it.
If one goes to the bottom of page 535, Lord Norman says, "My lords, I think that it does not do justice to the averments to take up each alleged incident one by one and hold that it is trivial or that it's not hurtful or cruel, and then to say that cumulative they do not amount to anything grave, weighty or serious." Reminding ourselves this is an old case, 1952, that the relationship of marriage is not just the sum of a number of incidents, and in this case it has been overlooked that all the incidents averred are said to have been inspired by the respondent's intention to impose his will upon the wife. Moreover, it's impossible in the bald averments of condescendence to convey the effects of conduct of one spouse on the feelings and through the feelings on the health of the other. What on paper may seem little more than a series of pinpricks may present a very different aspect when it's been developed in evidence, though the evidence does not exceed by a single word the bounds set by the record. And so a rather neat way, as it were, or embodying, we say, the complaint that we have in this case, that if one goes through, as we say the learned judge did, or except for his rather generic findings, as the President suggested they were, if one goes through a list of 27 particulars and says in relation to each of them, that is just the stuff of married life, and ignores the subjective impact, ignores the cumulative effect, one simply isn't A, posing the right question, or B, answering it in a proper fashion. And so we do rely upon Jameson, even though it is, as it were, on a slightly different point, as your Lordship suggested.
And it's also under the old law.
I'm so sorry.
It's also under the old law.
It is. But
so if that was true under the old law, you would say a fortiori under the new.
I would. It's certainly referred to in some of the later authorities under the new law. I was making the point about it's being suggested that we're asking the court to change the law and to overstep the constitutional boundary. We have well in mind the observations of Lord Hoffman in the case of Birmingham City Council and Oakley, which is in the First Authorities bundle at tab 11, page 663. I don't need to ask you to turn it up because it's in the President's judgment, where His Lordship emphasises that if one is going to, as it were, interpret a statute that is, to use the phrase, always speaking, one has to have regard to the fact that there mustn't be a conceptual difference. One can't simply, as it were, impose an entirely different meaning or concept upon the statute simply because one's interpreting it now rather than decades or indeed longer ago. And the President deals with this in his judgment at paragraphs 39 to 41. It's memory stick 194 to 195 of Law Bundle 1. And I don't presume or propose to take you to it. This is the analysis that ultimately ends up with the reference to the Boris bus and the Oyster card, having passed seamlessly through Victorian times and route masters to the present day. And there is, in my respectful submission, obvious, sound common sense in adopting this approach. We've identified what we suggest is the purpose of the original legislation, and provided one doesn't fall into the pheasant sort of trap of saying subjective impact means divorce unilaterally upon demand, then it's entirely right, we respectfully submit, that the court should have regard to current social trends, attitudes, including of equality and autonomy. None of the authorities to which the President referred in his judgment, I don't mean on this particular point, but in his survey of the case law starting at paragraph 27, none of them, of course, is binding upon this court. It doesn't, of course, I accept, mean that they're not good law, and indeed we recognise that they are. And in my opening observations, I simply indicated that what we are inviting you to do is as it were, to countenance a modest shift of focus, which more obviously has regard to the status of marriage, society's attitude to it. We've given some examples, some of them referred to by the President in his judgment.
And when you say society's attitude, I mean, what do you mean there? That society now expects that you should be able to get out of a marriage if you feel like it?
The research that was undertaken both by the Law Commission in 1990, and I tread cautiously, but also reflected in the Nuffield Foundation's research, actually indicates that there was large support for the idea that the basis of divorce should be irretrievable breakdown.
Yes, I mean, and that's the difficulty, that Parliament didn't adopt that.
No, I understand that.
And, I mean, are you saying that since the Act, in interpreting or applying it, we should recognise some continuing further social trend based on autonomy and considerations like that?
Yes, that's our case, and indeed...
Isn't the point that society's views of certain types of behaviour has changed?
Yes.
Rather than views of divorce, because that's a separate issue, not what we're about.
I respectfully agree.
But if we come back to smoking,
Yes.
which is a good example, smoking was taken for granted, certainly by my parents' generation, and yet it's not taken for granted by people today, and there are many people who consider it completely unacceptable that anybody should smoke in their house.
Yes.
And that may be even if you both started the marriage smoking, but one of you has given up and of course finds it even more unreasonable to have to live with somebody who's going on smoking because it makes it so much worse. But that's an example of how attitudes have changed to what is and is not reasonable to expect people to live with. And there are other things as well.
I respectfully agree. I mean, it's difficult in some respects, of course, to present any empirical evidence, as it were. How has society's attitude changed in a particular way? All one can try and do is to discern, in a sense reflected in the commentary that the President sets out in his judgment, as to how in other areas attitudes have changed. And so we've all given, as it were, in our respective written cases, the obvious examples of White and Miller and Macfarlane, in which decades of case law as to how to interpret the Matrimonial Causes Act, I know your Lordship was involved in the cases, as I recall, what was, as it were, positively endorsed by the Court of Appeal in Dart and Dart. Mr. James Mumby, Queen's Counsel, then arguing the case for the appellant. And indeed, when we came before the court in the House of Lords, as it were, in White, the point that was being relied upon is there is a seamless, reliable body of case law, and there's no need to interfere. And indeed, my learned friend is rather making that point in this case, which is, well, what's wrong with the authorities as cast? Why is there any need to interfere? And of course, that really carried no weight at all with the House of Lords in White. Similarly, in relation to MacLeod, as I indicated, the Privy Council case about, I think, a post-nuptial agreement, in which, of course, as your lordships and ladyships are well aware, issues of public policy were said to have become redundant. And for a brief period, we had a curious situation where post-nuptial agreements were not contrary to public policy, but pre-nuptial agreements were, until the court in Radmacher and Granatino, this court, similarly took the matter forward, reflecting entirely issues of autonomy and what is thought to be acceptable or unacceptable. And that, we would respectfully submit, is both White and Miller and MacLeod and Radmacher are in a sense good examples of how the court has moved forward. It didn't, as it were, require a radical reinterpretation of the statute. That would have been impermissible under the Oakley test. What it required was a change, a shift of focus in the way in which the court approached, applied or interpreted the statute and the powers that were given to the court. I mean, we tend to think, as it were, of White as being something of a radical breakwater point. Could I ask you just very briefly, please, to turn to Authorities Bundle 3, tab 34, memory stick 1187, to the case of Midland Bank and Green, which is a case decided in 1981 by the Master of the Rolls, Lord Denning, Lord Justice Fox, and Sir George Baker. It was interesting, eating only into my own time, to see that junior counsel in that case was one much younger James Mumby, appearing on behalf of the applicants, and was seeking to uphold the concept of unity between husband and wife in the context of a tortious conspiracy. On memory stick page 1196, the Master of Rolls observed laconically, "I'd like to thank Mr. Mumby for his most able discourse. He's brought before us all the learning upon the subject from the book of Genesis down to the present age. I hope he'll forgive us if we don't go through it all." Nothing perhaps changes markedly. But the point I wanted to deal with is at the bottom of that page, where Lord Denning in 1982, ahead of his times, but entirely, of course, consistent with the approach that his lordship had adopted in the case of Wachtel, speaks there at letter G. "Nowadays, both in law and in fact, husband and wife are two persons, not one. They are partners, equal partners in a joint enterprise, the enterprise of maintaining a home and bringing up children." And so he goes on to say why it was appropriate in 1982 to sweep away the whole fiction of presumed unity between husband and wife. And if I could ask you to turn, and forgive me, I think this is in our note, if I'm repeating it, I apologise, to memory stick page 1200, there's a short, but we say enlightening, judgment from Sir George Baker. The law, at letter F on that page, "The law is a living thing. It adapts and develops to fulfil the needs of living people, whom it both governs and serves. Like clothes, it should be made to fit people. It must never be strangled by the dead hand of long discarded customs, belief, doctrines, or principle." And we say in essence, that's what this court should consider in the way in which we suggest in this case. I was going to deal very briefly, and I will deal with it very briefly, with the case law. Can I invite you to it's set out, and I think I took you to it, it's Core Bundle 1 at page 190, starting at page 27, where the President surveys the various authorities. We don't suggest that the approach which is adopted here is wrong. I referred to the old authorities, the pheasant and cats and ash, and I don't propose to go back and look at those points. But your lordships, your ladyships and your lordships will see on page 191 the way in which the case law developed, at the bottom of page 190, at paragraph 29, Livington Stallard, where Mr. Justice Dunn postulated something equivalent to a direction to a jury. I asked myself the question, would any right-thinking person come to the conclusion that this husband has behaved in such a way the wife cannot reasonably be expected to live with him, taking into account the whole of the circumstances? That was endorsed in O'Neill. Lord Justice Kearns at the top of page 191 in reliance upon a passage in Raydon, and then more fully by Lord Justice Roskin, although the President doesn't set out there what precisely he says, but for your note, it's,
So which case are we talking about?
We're talking at the moment about O'Neill, at the bottom of page 192. At the bottom, Lord Justice Kearns, one considers a right-thinking person looking at the particular husband and wife, that's a subjective element, and asks whether one could reasonably be expected to live with the other, taking into account all the circumstances, respective characters and personalities of the two. El-Raj, which is in the middle of page 192, it was in fact a case on an entirely different point. It was as to whether the wife in Balraj was able to make good a claim under Section 5 of the Matrimonial Causes Act, so to resist the making of a decree based upon 5 years' separation. But in fact, Lord Justice Cumming-Bruce set out what we suggest is a good and pithy analysis of the approach that should be adopted. And he says 3 lines down, the court has to decide the single question whether the husband, for example, has so behaved that it's unreasonable to expect the wife to live with him. And then this, we say, is important. In order to decide that, it's necessary to make findings of fact of what the husband actually did, and then findings of fact upon the impact of his conduct on that particular lady. Well, that's the approach which we invite you to adopt. It's a question of how much emphasis or weight is then put upon the impact of his conduct on that particular lady. As has been said again and again, between a particular husband and a particular lady whose conduct and suffering are under scrutiny, there's of course a subjective element in the totality of the facts that are relevant to the solution. But when that subjective element has been evaluated, at the end of the day, the question falls to be determined on an objective test. And that's of course, is it reasonable?
Yes, and the reasonableness test, I think, Raydon on divorce at the top of that page says it depends on whether the cumulative conduct was sufficiently serious to say that from a reasonable person's point of view, reading short, the conduct is such that this petitioner ought not to be called upon to endure it.
Exactly.
You don't take issue with that?
No, we don't. I mean, I hesitate only because of the significance what might attach to the phrase sufficiently serious. But
Surely one should actually be looking at the way in which the point has been put in the Court of Appeal cases, which have, I think, uniformly adopted the Livingston and Stallard
they have, although
approach, which is not identical to the Stevens approach.
It's not identical, but I think the problem creeps in because the Radin is
Yes, well, let's forget about Radin. It's a work of authority, of course, but actually the authorities in the Court of Appeal are of more importance.
I respectfully agree. I was only going to say that in the Court of Appeal there are a number of authorities where the passages in Radin have been approved.
Cited, yes.
And so in a sense its status is elevated to the approach adopted in those Court of Appeal cases. So, for example, in O'Neill and indeed in Buffery.
Well, in Buffery, Lord Justice May said the gravity or otherwise of the conduct complained of is of itself immaterial.
Yes.
The point is what? What is material?
Yes.
Well, I'd like to
Mr. Justice Dunn, however, was clear that gravity was immaterial. It's at the bottom of page 190.
Well, is that right? That doesn't appear to me from that passage.
It's not, forgive me, from that passage. Perhaps we should go to Livingston Stallard and have a look at it. Its authorities bundle 3 at... Sorry? Thank you. 1123, I think. His Lordship deals with the point on page 1130. And in the middle of the page, Mr. Rees, the husband, has referred me to the cases, all of which have been so far decided at first instance. This is the triumvirate of cases, Ash, Pheasant and Cats. And your ladyship will see in the middle of the page at D going to E. I have in the past followed the reasoning of Ormerod J in Pheasant and Pheasant, but on reflection with respect, I'm not sure how helpful it is to import notions of constructive desertion, nor, speaking for myself, do I think it is helpful to analyse the degree of gravity of conduct which is required to entitle a petitioner to relief under section 1.2b. Lord Denning has emphasised in another context that the 1973 Act is a reforming statute, and then he says section 123 is very simple language, which is quite easy for a layman to understand. Well, we would respectfully agree with that. And then he goes on to talk about his direction to the jury. So your Lordship will see that he specifically rejected weighing gravity when considering whether it was reasonable to expect the petitioner to continue to live with the respondent. That is taken up, as I've said, both in O'Neill and in Buffery, and effectively is the approach now reflected in Radin. And so if one looks at the middle of page, memory stick 192, in Buffery and Buffery, Lord Justice May, this is paragraph 33 of the President's judgment, the gravity or otherwise of the conduct complained of is of itself immaterial. What has to be asked, as will appear from the judgment in it, is whether the behaviour is such that the petitioner cannot reasonably be expected to live with the respondent.
Can I just be sure that you are accepting the jury direction as the right formulation?
I think it reasonably reflects the objective test, a right-thinking person. But our analysis, our approach, I can indicate, and we've put it in that little schedule that we placed on your desk, is that if one is true to the approach adopted in Balraj, where one has to make factual findings about who did what to whom, why and when, and factual findings as to the subjective impact upon the respondent, and then ask the statutory question, is it reasonable? It has to be reasonable from the viewpoint of a right-thinking person, hence the jury direction. But as we've suggested, what one would have regard to the subjective impact. And you'll see in the schedule that we've placed upon your desk, we hesitated in a sense to put this in because in some respects the analogy with reasonable force might be thought to be rather strained because of course it's a creature of statute now. But we've tried, as it were, to identify at each stage what the court should be asking itself. So under 1.2b, decide what the respondent did or did not do. That's a factual finding. Decide what the effect of the behaviour is on the petitioner. That's Balraj stage 2. If the petitioner's perspective is genuine, it doesn't matter if it's mistaken or not. Well, that, we say, echoes the approach under the statute in relation to reasonable force. And then the objective stage, what may be regarded as trivial in the Court of Appeal, the court said, what may be regarded as trivial disagreements in a happy marriage could be salt in the wound in an unhappy marriage, i.e. the unhappy petitioner cannot necessarily weigh the respondent's behaviour objectively. The fact that the petitioner honestly perceives that he or she cannot live with the behaviour of the respondent is strong evidence, i.e. not determinative of the fact that he or she should not be expected to live with it. The petitioner's view will not, as I've said, be determinative, where, for example, it is disproportionate, where, despite the views of the petitioner, the court is of the view that the living with the respondent may enable the marriage to be retrieved. And we had in mind, for example, gravity, for example, might be relevant to, it would be relevant in relation to self-defence in evaluating genuineness. We accept that. If the conduct is very trivial and of no moment or consequence at all, the court may simply reject and not be able to make a finding of fact at stage 2 of Balraj as to its impact upon the particular petitioner. But assuming it has, and we had very much in mind, and it's a point we make later in our written case, my lady, in the case of In Re B, the appeal in relation to the making of a care order in which Lord Wilson gave, I think, the lead judgment, but there was no disagreement between those two members of the court, or your ladyship and your lordship, on the issue that although there are primary findings of fact to be made, and that's Balraj stage 1, and primary findings of fact to be made Balraj stage 2, when in Re B, the court considered whether the threshold had been passed, that was said to be a value judgment. And that echoed the approach which my Lady Black had taken in the Court of Appeal, I think, that it was a value judgment rather than, for example, a discretion. Now, that's relevant to a different point, which is the entitlement of this court to interfere or not in relation to the approach or the findings that the judge made at first instance in this case.
Mr. Marshall, you spent 75% of your time on principle, and no doubt it's been very helpful to us. You've got 25% of your time left and it may be it's entirely a matter for you that you might like soon to turn to the application of all these principles to this particular case and to this particular judgment.
Yes. Can I do that straight away? You have in the papers before you, and I'm not going to take you to the petition in its amended form. We've invited the court to read that in our note. Mr. Dunlop and I each produced, and it's in the second core volume, respectively at 320 and 345, we each produced chronologies of the various events upon which my client placed reliance. I would invite you to look at that because, A, we haven't put it into the Statement of Facts and Issues, and I appreciate the court will not go behind the Statement of Facts and Issues, but it does assist in my submission in being able to fix in one's mind the chronological sequence of the complaints that are being made. And that goes very much to the issue of the cumulative impact that the conduct, we say, had upon Mrs. Owens, as reflected in the references that we've set out in the text. We've raised a number of complaints in relation to the judgment at first instance in our written case, and it's at page 94 in Core Bundle 1, and may I ask you please just to turn that up.
Page number again, I'm sorry?
94, my lord.
Thank you.
It's section F in our document, the errors of His Honour Judge Tolson. I've already outlined that we say there are a number of respects in which the learned judge simply didn't apply the law, even before one considers the re-emphasis or the refocus that we would invite you to endorse in relation to the status and the weight of subjective impact. Principal amongst them is, as I've already indicated, that the learned judge fell into the linguistic trap.
Yes, I mean, you mentioned that already, but is that entirely fair? Paragraph 10 of his judgment seems to be a very accurate summary of the statutory language, doesn't it?
I don't necessarily take issue with that suggestion, my lord, but what is, in my submission, significant is to see what his lordship, what the learned judge said in the very next passage. I mean, we've set out in our written case, and I'm not going to take you to it, but if one turns back, forgive me, to 215, at the very first paragraph, the learned judge referred to unreasonable behaviour.
But this is code, as you yourself said. You used the phrase, and
no, I used it once,
and Resolution have used it, and they. When you see in paragraph 11, immediately after paragraph 10, him use the phrase, surely he's just using it as convenient code for the full test, which he's set out explicitly and carefully.
Well, my lord, I respectfully don't accept that, because if one goes, for example, to paragraphs 6 and 7.
And his conclusion is in those terms, isn't it, as well?
At the very end, his lord, the judge effectively said that he didn't find, if one's thinking about paragraph 15, I find no behaviour such that the wife cannot reasonably expect to live with the husband. But that presupposes what test he set for himself.
Yes, I mean, normally we give the judge the credit of thinking that he understands the law, and we aren't unduly particular or pernickety about the use of what appear to be in the profession quite common shortcut usages.
Well, my lord, I understand, as it were, the hurdle that I have to address. I'm well aware of the approach in the Carlisle case. I'm well aware of Piglowska, all of those authorities. I think Carlisle's in the bundle. We haven't put all of them in the bundle. But, my lord, although I accept that one has to read the judgment as a whole, one has to look at substance and not semantics. If, my lord, one, upon a proper analysis of the judgment, is driven to conclude that what the learned judge, when the learned judge, as it were, rejects these complaints as trivial or minor altercations to be expected within a marriage, we say inherent within that is precisely the assumption or the requirement, that something more serious, more grave, more weighty would only suffice. It's not just the use of the word unreasonable, it's how the learned judge categorises the conduct and the behaviour at each stage of his analysis. And so if one looks at paragraph 7, for example, even before the petition was amended to plead detailed allegation, it's instructive to examine the first ground upon which the petitioner's behaviour is said to have been unreasonable. And one goes on, as I've said in paragraph 11, I would not have found unreasonable behaviour on the wife's pleaded case. And going over the page on to 219, as it is, having heard both parties give evidence, I'm satisfied the wife has exaggerated context and seriousness of the allegations to a significant extent. They are all at most minor altercations of a kind to be expected in a marriage. Well, Lord, even assuming that they were, and we don't accept that that's right, but I appreciate the difficulty I have in inviting you to find otherwise, the learned judge doesn't go on to deal with the pinprick argument, as it were, the cumulative impact upon this particular petitioner. He doesn't go on to make findings in relation to the subjective impact upon this petitioner set out in full in our note, as Balraj requires. Second stage of primary findings of fact. And although in the Court of Appeal the President said, well, actually, the only thing the only task that he had was to answer the statutory question, is his behaviour such as it wouldn't be reasonable to expect my client to continue to live with him? That's a little bit, in my submission, like saying, well, the only question a judge has to make, for example, in a case like In Re B, is whether to make a care order or not. And the President cited his own observations in Re F. That's the case where he also cites Mr. Justice Mostyn about judges not having to go through exams and not having to go through the pre-flight tests. But actually what Sir James Mumby said in Re F is that the judge had, as it were, to demonstrate with sufficient detail so that one could understand that he'd gone through the right process. I mean, it would be no more acceptable, in my submission, in a case equivalent to In Re B, the public law case, for a judge to say, well, I've heard all the medical evidence and I reject it. Because that's in essence what the judge has done in this case. He's categorised it simply as either exaggerated or taken out of context. Doesn't say why. There were some allegations which Mr. Owens didn't dispute, and which, in relation to which the judge didn't make findings at all. I mean, we've said in our note that, and I ignore it for a moment, the sort of blanket generic finding, they're all exaggerated or taken out of context. In essence, in relation to 23 out of the 27 particulars, no findings were made at all. And it might be said to be a sense of grievance on my part, and I apologise for that, in a sense, having fallen into the rookie's trap, as it were, when the judge said, what are your 4 most serious complaints? I suppose the proper answer would have been all of them. But I didn't do that. I said, here are 4. The judge dealt with one of them.
But, I mean, the point made against you is that it was understood that the trial would proceed in a particular way. It was a very short period of listing, and you didn't complain at the time when it did proceed in that way.
Well, my lord, in fact, the evidence unfolded in a slightly different way, because although I wouldn't for a moment suggest that one should start to look at the transcript, but Mr. Dunlop cross-examined not on all of the allegations, but on many of them. I cross-examined on not all of them, but on many of them. I entirely accept, I can't go behind, as it were, the face of the transcript, that I said I'm only going to focus on 2 or 3 or 4, I think I said, and the judge took that to be a agreed approach. It would have been open to the judge, in my submission, to say, well, I've considered grounds 10, 15 and 16. I find those proved, and that is of in itself sufficient. And that's to the extent that these hearings are ever common, that is often an approach which is adopted, which is I'll simply focus on the most serious. What in my submission is not appropriate is, as it were, to analyse only a very few of the top 4 that I'd identified, which had a common characteristic of having been incidents that took place in public. The airport, the pub, the restaurant, and the housekeeper incident. Mr. Dunlop cross-examined, and this is set out in the President's judgment, cross-examined for about 20 seconds on that. I cross-examined at some greater length. He didn't cross-examine at all on the housekeeper point. And the learned judge made no findings in relation to that. And we do say that if there is an absence of findings of fact and an absence of an approach which requires a cumulative assessment of the impact and an absence of any findings in relation to the subjective impact upon my client, then even though the hurdle in Carlisle and in Re F is set quite high, on a proper construction of the judgment, or a proper reading of the judgment, it simply fell into error. And I appreciate that a good deal of latitude is given to judges at first instance. I appreciate that the court, whether in the Court of Appeal or indeed at this level, will not start to investigate.
How could he have dealt with the others in practice in the absence of cross-examination in detail on them? I mean, basically, you're saying he should have said, look, before I reject the whole case, fine if I find it proved by reference to 1 or 2 instances, but before I reject the whole case, I need to investigate all these in detail.
Well, my lord, what he could have done, for example, is to say, as is often common, where there is a disagreement between the parties, I prefer the evidence of the husband or I prefer the evidence of the wife. He did say...
Well, didn't he say that?
Well, he didn't quite say that, my lord. He effectively said that my client had exaggerated the allegations or taken them out of context. But he didn't, for example, go on to say, even in relation to those about which there was no dispute, or which were admitted, although my learned friend Mr. Dunlop invited the judge to look at them within context, which itself ignores the subjective impact upon my client. He simply didn't deal with those matters. And although I appreciate you won't descend into the particular facts, particular instance, but the housekeeper incident, for example, is a very good example, we would respectfully suggest. This is of sending your wife out into the garden to pick pieces of cardboard up off the lawn, having reprimanded her, as my client suggested, in the presence of her housekeeper. Now, whether that would have been acceptable in 1969 or 1968 is debatable. Whether it's acceptable now, And if that has, for example, the effect upon my client that she suggests in her statement that it had, embarrassment, discomfort, and hurt and upset, that's precisely, in my submission, the sort of allegation on the sort of pinprick approach which the court should have considered cumulatively and having regard to the overall evidence which wasn't challenged as to how it impacted upon my client.
Mr. Marshall, I wonder whether we can be educated by you and Mr. Dyer in due course about the realities of this sort of dispute, a defended divorce.
Yes.
Might it not be the position that practitioners expect these defended divorces to end up with the grant of a decree?
Yes.
Might it not be the position that just as this recorder doing directions 4 months before the case seems to have said, well, only a day, you'll only need a day for this, and only the husband and wife will give evidence. Mr. Dyer, we haven't seen the order, but Mr. Dyer says there was a direction that there be no other witnesses.
There was, and there were.
But it didn't stop Mr. Dunlop in his final submissions to the judge saying, well, where's the corroborative evidence? I don't understand that particular aspect, but put it on one side. But the whole tendency is to keep these defended divorces within a very short and constrained time frame and subject frame on the basis that it's likely to end up with the grant of a decree.
Yes.
And I just wonder whether, in circumstances where, having heard your 4 allegations, the judge is not particularly impressed with the case, whether it might have been fairer to say to you, well, in the circumstances, Mr. Marshall, I don't think you should be held to your presentation simply of if you've pleaded so many more. I don't think you should be held to your presentation of 3 or 4.
My Lord, Your Lordship's analysis, in my submission, respectful submission, is entirely right. I don't think there was anybody in the courtroom who expected the petition to be dismissed, and you've seen reference.
Well, I'm talking about this case. I'm talking about generally.
I beg your pardon. Yes, but I thought Your Lordship said that
yes.
one approached these matters procedurally in the expectation.
Yes.
Not only in the expectation that that is what will happen, but also in the hope, because that is a universal hope, of not making things worse between the parties, rather than, this is the whole tenor of things. This is why your petition was initially so short and only got particularised once it had been defended.
Well, quite so. I mean,
it's all in the business of trying to keep the temperature low.
It is, and I cross-examined Mr. Owens along those very lines, which is what happens next if the petition is dismissed, because your ladyship knows that his expectation was there would be a resumption of cohabitation. I mean, we do say, and I'm not going to repeat the points I've made, that the hearing was unfair. The President rejected that because he effectively said, well, you were the architect of your own misfortune by taking a pragmatic approach. One hopes at each stage in the litigation. You can't, as it were, cry foul when things don't go the way that you expect them to go. And we did, as you will have seen, invite the learned judge to provide further elaboration of his judgment, either in terms of other particulars, and he refused that on the agreed approach basis. And the President said, well, that was entirely justifiable. Can I suspect in the very few minutes that remain to me, I'm so sorry, simply deal with the points that we've made in relation to the Court of Appeal. I mean, our approach in essence is this: if the trial judge did not apply the law correctly, then obviously the suggestion by the Court of Appeal that he did simply cannot stand. And even if the law was as the President set it out, we invite you obviously to say that there should be this refocus, this re-emphasis upon the weight to be attached to subjective impact, matters the judge simply didn't deal with. I've alluded already to the fact that in the Boris bus passage, as it were, the President indicated that one had to look at the statute in modern times, not doing violence to its language, but for all the reasons that I've already elaborated. We say it was illogical, as it were. It's not at all apparent from Judge Tolson's judgment that he adopted that approach. I mean, I can't, as it were, point to something absolutely contradictory and say he plainly didn't adopt that approach, but almost by silence and omission, it's apparent that he didn't. And nowhere in the President's, in the decision to uphold Judge Tolson in the Court of Appeal, again, is effect or account taken of the need to have regard to all of those matters which the President then set out in his judgment to justify the modern ethos, modern approach. And we would invite this court to say that for that reason, if the decision of Judge Tolson simply doesn't take that into account, then the Court of Appeal was wrong to uphold his judgment, having itself identified the need to take these matters into account in the way that the President has set out. I mean, it poses some difficulty for us, in a sense, because one of our complaints is, well, the judge just didn't grapple with the factual matrix on a Balraj approach. Although we pray and aid this court's ability, greater ability, applying in re B, where both Lady Hale and Lord Wilson said that if it's a judgment rather than an exercise of discretion, it's an evaluation. The test is not plainly wrong. We're not in G&G territory, as it were. This court would still have to be satisfied that the judge was wrong. I do say that you can be satisfied of that. The difficulty, in a sense, that we face is if you're with me on all of that, including the need to move the law onwards, progressively onwards, as we've seen in other areas, what happens next? In our written case, we invite you to certify that my client should be entitled to a decree on the basis of the uncontested evidence in relation to the impact upon her and upon the uncontested evidence, the complaints, to the extent that they are apparent from the pleadings. The alternative, of course, is to send the matter back for a retrial. And you will appreciate immediately that is something that would fill my client with particular dread. We're 2 years, slightly less than 2 years away from 5 years separation, and she would be faced with a dilemma, whether to press on with a retrial or to simply wait 5 years and say by default, through nobody's fault in essence, from the date of her petition, it's taken us the best part of 2.5 years to reach this court. Not a complaint, simply a statement of fact.
That problem must have been thought about when the decision was taken to appeal to this court.
Of course it was. I mean, it may be that finally, if I say some sense, I appreciate a sense of sense is a very subjective matter, but some sense may prevail. Plainly, at each stage, there has been encouragement to try and resolve this dispute. In Resolution's case, and I put the matter entirely neutrally, and I hope not in an emotive way, in a sense they've said that Mr. Owens has the satisfaction, as it were, of having prevailed at each stage in this litigation, whilst enjoying none of the benefits of the marriage and married life to which he aspires. And which as long ago as the trial, Judge Tolson said he was deluding himself if he thought there was going to be reconciliation. And so we do invite you to, as it were, seize the opportunity to bring this matter to an end, assuming you are with us in relation to the proper approach that the law should now adopt, having identified the additional failings, as we respectfully suggest, apparent on the face of the judgment.
Can I just go back a second? You used some shorthand a moment ago, speaking of re B and evaluation rather than discretion, I think, and not being in G against G territory. We haven't got those authorities. Do we have them?
You do have in re B, yes. I think it's volume 5 at tab 47. My Lord Wilson's analysis begins at page 1713, memory stick 1713, under the heading Appellate Review of Determinations Made in Care Proceedings, but more particularly at paragraph 44. I think that there's an error sometimes in the law reports, and indeed I think my own friends in their case have ascribed to Lord Wilson something that Lord Neuberger said at paragraph 53, which was altogether different. But in fact, the relevant paragraph is 44.
Right, which bit?
And Lady Hale's observations begin at page 1757, paragraph 199, the appellate function, where there is this three-stage analysis. The first are decisions of facts, for example, who did what to whom and in what circumstances. Second is the decision as to whether the threshold is crossed. Involves various questions set out in paragraph 193 above. And then the final question is what order to make. And it's from this that I've collected the observation that Lady Justice Black, as she then was, looking at letter H, in the Court of Appeal in this case, Lady Justice Black was also inclined to categorise it as a value judgment rather than as a finding of fact or an exercise of discretion. And when I refer to cases such as G and G, Your Lordship finds that in Lord Wilson's judgment and in various other places. It's at page 1713 at paragraph 37, where it was said that obviously if the court is exercising a discretion because of the wide ambit, etc., the decision had to be plainly wrong.
And what is the threshold in this case? The threshold was what?
But
whether the child was likely to suffer significant harm, is that the reference? Yeah.
Yeah.
So you're saying, obviously, whether paragraph B is met is a mixture of findings of fact and then evaluation of those findings of fact in the light of the test, whatever it may be.
Yes.
And that is in no sense an exercise of discretion.
Well, indeed,
the judge doesn't have a choice.
It's quite the opposite.
Yes.
It assumes the judge tries to collect what a right-thinking person, not the judge, might consider reasonable. There might be a happy coincidence, or there might not.
But that said, I mean, I think you'll find, well, I don't know about this area of the law, but there's quite a lot of authority that evaluative decisions, judges are given a certain scope of, judgment, essentially.
They are, and that's why I conceded, as it were, that even in so far as an evaluation is concerned, the test would still be wrong. I think Lady Hale said, well, the word in the CPR is wrong, and adding words such as plainly or such like adds nothing, and we shouldn't do so.
I mean, wrong doesn't just mean I disagree with it.
It doesn't, but then one looks at the Carlisle case, one looks at the Henderson case, one looks at the I forgot the name of it, McGraby case, as to the circumstances in which then the court would be entitled to interfere. I haven't taken to that, but it's dealt with in the President's judgment. It's in the bundles, and it's in Malone and Friends' case.
And of course, there is Lord Newberger's analysis of what is meant by wrong.
There is.
Paragraphs 93 and 94 of B.
Yes. Yes. Yes, indeed. I think
This is all about proportionality, but nevertheless,
it is. I mean,
proportionality is an
there was obviously a
judgment
different
as well.
issue in that case as to proportionality in making those sort of orders. Can I simply, by way of repetition, make a final point? And it's the one I made about, I appreciate my time is about to be up in about a minute, I think.
I think it's up. One sentence.
One sentence. That's a challenge. That's not my sentence. One sentence. If the court thought we were pushing the revision too far, Article 8 is engaged, and the court should read down Section 1.2b in the way that resolution suggests in its case. I haven't argued that, and it may be that it doesn't persuade itself to all members of the court, but I simply invite your attention to it.
I think that was one sentence, Mr. Marshall.
It was a long sentence with...
Well, one can string out sentences almost indefinitely.
Unless I can assist anything.
Thank you very much indeed. Mr. Jarmin? Mr. Dyer?
May it please you, my lady and my lords. I'm going to concentrate my submissions on 5 specific topics, and if I can outline them for you. The first topic is obviously the most important one, the interpretation of Section 1.2b. In relation to that, we say the meaning of the words in the statute is clear, and that the test laid down by the Court of Appeal in this case, which followed a long line of consistent authority on the law to be applied in defended cases, should be approved by this court. And in particular, I'll call it the jury direction in Livingston-Stallard. The second topic is to address Malone and Friends' case on the subjective interpretation of Section 1.2b that they now contend for. We say, if you take subjectivity too far, then in effect you have divorce on unilateral demand, which is impermissible as a matter of statutory construction. The third topic is the one Malone and Friends just dealt with, and that is his criticism of the approach taken by the trial judge to fact-finding in the trial process. In relation to that, we say that this court should not re-enter the factual arena, especially when the same points were run in the Court of Appeal and rejected unanimously. As there has been effectively the indulgence of concurrent fact-finding, another bite of the cherry in this court, we say, is neither needed or appropriate. The fourth topic, I'm going to address convention rights, Article 8 and Article 12. We say that Article 8 rights and Article 12 rights are not infringed by the application of Section 1.2 of the 1973 Act. And there is clear and constant Strasbourg authority that Article 8 and Article 12 cannot be interpreted as conferring a right to obtain a divorce. And a fortiori, there is no right to a favourable outcome in domestic divorce proceedings. That's the case of Babiage and Poland. And we invite this court, pursuant to Section 2 of the Human Rights Act, to follow that jurisprudence, applying the mirror principle. I will address also the intervener's invitation to read down Section 1.2b under Section 3 in order to provide a subjective test. In short, we say the section is convention compliant and a new interpretation is unnecessary, and it would be quite wrong to interpret a section, to reinterpret the section in a manner which is quite contrary to what Parliament intended the divorce law to be and how it would operate. And then finally, my final topic will be short. I'll just address the always speaking statute point. So if I could begin, please, with the interpretation of Section 1.2b. And I'll start where my learned friend did, which with the observation that the trial judge made very early in his judgment that the marriage had broken down. We say that in the context of the appellant obtaining a decree nisi, that observation is really neither here nor there. Because what the law requires is one of the 5 facts to be proved to the civil standard before the court can consider the only ground for divorce, obviously that the marriage has broken down irretrievably. And that is obviously very clear from the opening words in Section 1.2 by the use of the word unless. If the petitioner cannot establish her fact, then the judge simply does not reach the question of whether the marriage has broken down irretrievably. And if authority was needed for that proposition, we have the case of Buffery in the Court of Appeal at page 671. This confirms that the specific fact must be proved independently of irretrievable breakdown. Now, Parliament has delineated 5 situations through which the judge is exclusively permitted to reach the irretrievable breakdown findings. Now, this requires that the judge must be clear through his or her interpretation of those 5 facts, not to render them meaningless, because they are essentially, in practice, the ground for divorce in another guise. In Pheasant, which I'm going to refer you to later, Mr. Justice Ormerod, as he then was, explains that Parliament never intended that the irretrievable breakdown point was to be justiciable. It was not an issue that the judge actually had to decide upon, because if the fact was proved, then subject to a last-ditch defence from the respondent, irretrievable breakdown could be found.
What was the reference to that again?
The section, my lord.
No, to Parliament never intending. It was pointed out.
Oh, it's the case of Pheasant. I'm going to take you to that in due course. So the facts are important. And as my Lord Hodge said, they are the gateway to the ultimate ground being established. Now, turning to the actual words of the statute, there is quite a lot of common ground between my learned friend and I. The court is obviously not concerned whether the behaviour complained of caused the breakdown of the marriage. It's not a question of causation. It's not a condition of the behaviour complained of that it has to be blameworthy or culpable. Fault is not a legal requirement. And the best example of that is the case of Thurlow in 1976, which is at page 1108, where a decree was granted to the husband whose wife had been suffering from a mental illness and who was detained in a mental hospital. She was not in any way held to be blameworthy. In fact, her behaviour was quite involuntary. But the court held that the husband could not reasonably be expected to live with him. Now, neither the statute or any of the authorities have set a behaviour threshold or standard or a high watermark. And it's quite clear, certainly from Livingston-Stallard, which my learned friend showed you, that the judges have rather shied away from expressing any views on that, and they tend to deal with the matter case by case. And that is what the law commissioners in their 1990 report, the ground for divorce, effectively endorsed, because they described the test of whether the petitioner can reasonably be expected to live with the respondent as being a flexible concept. That's at page 210, at page, paragraph 210 at page 2203. They wrote, it is a flexible concept which varies from case to case and court to court.
Oh, well, yes, that was an empirical finding about its varying from court to court.
Yes, well,
it varies from case to case, of course,
yes,
because one is looking at this particular marriage and these particular people. But we had also found that we were talking about undefended divorces, of course, but what you had to establish to get a divorce in, shall we say, County Durham was rather different from what you had to establish to get a divorce in Oxford or Cambridge.
Yes, understood. But
no prizes for guessing which way round.
Quite. But we do say that the appropriate way to look at any threshold is to see it as a flexible concept. And of course, behaviour petitions may well, and often do, contain allegations about the respondent's behaviour which is indeed blameworthy and culpable. I mean, that does happen, even though obviously resolution tries to promote anodyne petitions. Certainly there are some quite hard-hitting petitions. So the behaviour allegations should really be viewed on a spectrum. At one end you have domestic violence, obviously at the very serious end, and then at the other end of the spectrum you have the insignificant complaints, the criticisms, the stuff of everyday married life, which is really what the judge found here. Because in every case, the judge is going to be faced with a series of criticisms and complaints. And it's a matter for the judge to obviously put those criticisms on a certain scale. And it's impossible to set a standard or really come up with a form of words to express that. But obviously he is having to deal with behaviour such that, to use the words of the statute, the petitioner cannot reasonably expect to live with. Now, the essence of the task imposed on the judge by the statute is obviously to decide by the contemporary standards of the reasonable man and woman, not what is reasonable or unreasonable behaviour per se, but with what behaviour can one spouse be reasonably expected to bear, bearing in mind the characteristics of both spouses. That, we say, is the test, or the task. We quite agree that to describe the respondent's behaviour as unreasonable behaviour is a potentially misleading shorthand. And although the trial judge did use that word, or use that expression, he did apply, we say, the correct test. And he just fell into the vernacular. Not surprising when faced with Maloney Friend's opening note in writing, which actually said, you are dealing with 27 allegations of unreasonable behaviour. So it's hardly surprising. Looking now at the test itself, what we say is that there are three stages for the trial judge to consider when trying a behaviour petition. The first stage is a fact-finding exercise. What did the respondent actually do? The second stage is a value judgment undertaken by the judge.
Well, what did the respondent actually do or not do on some
Or not do, yes, abstain from doing.
Failure to act can, on occasion.
Yes, I agree. The second stage is the value judgment stage. And the question the judge has to ask is the respondent's behaviour as found such that the petitioner cannot reasonably be expected to live with the respondent, taking into account all the circumstances and the personalities of the parties?
So do you disagree that there is a stage after the fact-finding? What was the behaviour? What was the impact of that behaviour on this particular petitioner? Do you not have to ask that?
That's in the second stage.
But you've wrapped that up in the value judgment.
Yes. Yes.
I thought that was a fact.
No, the fact is, what did the respondent actually do?
But isn't it also a fact what was the effect upon the petitioner?
Well, we say that fits better into the second stage. It's a value judgment because you're looking at assessing her reaction to the behaviour.
Oh, we may be playing with words here,
Yes.
but I'm just sticking with the Balraj 3 stages. You find out what was done or not done.
Yes.
You find out what the impact of that was on the petitioner.
Yes.
And then you ask, well, in the light of that, is it reasonable to expect this petitioner to continue to live with,
Yes.
or to live with, because they're not always continuing to live with.
Yes, I would disagree with that.
Yeah.
I mean, the first stage is effectively pure fact-finding. It's not importing any value judgment. Because you have to balance one person's perception, the petitioner's perception, with what's happened with the respondent's personality. I mean, to use the smoking example, she complains about smoking, but actually smokes herself. I mean, those are value judgments that are going to come in at some stage. I mean, there has to be a time when the judge makes a value judgment, taking into account.
I wasn't putting to you that there isn't a time about when a value judgment is made. That is, of course, correct. I was only putting to you that the conduct complained of has to be evaluated in the light of the impact of that conduct on, and the authorities are completely clear about that.
First stage.
Yeah.
Yes, yes.
So it's a second stage.
But at the second stage, if it's the smoking example, she says, it makes all my clothes smell. My friends are saying that it's bad. I am finding it difficult to breathe, etc. It's a fact-finding as to whether that's true
Yes,
or not, isn't
yes,
it?
Yes, I agree.
So there are actually possibly two parts to the fact-finding exercise. One's
Yes.
what he did.
What's he done?
And the other is
And the
what's
effect
the
on her.
impact.
And the effect on her.
Yeah.
Yes, I agree.
And then the evaluation.
I agree, yes. And then the third stage is if the answer to stage 2 is no, then the petition is dismissed, and if the answer is yes, then the court has to consider whether the ground that the marriage has broken down irretrievably has been satisfied, which by that stage is axiomatic. The proof of the fact establishes the irretrievable breakdown.
Well, apart from subsection 3, is it 4?
The last ditch.
Yeah,
Yes,
it's not necessarily a last ditch. It's there in the Act.
yes, it's...
If the court is satisfied on the evidence of any such fact as is mentioned in subsection 2 above, then, unless it is satisfied on all the evidence that the marriage has not broken down irretrievably, it shall grant the decree.
Yes.
So it's quite clear that there is a potential.
Yes, that's the...
This is 494.
That's the respondent's...
Subsection 4.
Yes, that's the respondent's last opportunity, effectively.
Could I?
Is there substance in practice in that opportunity?
Very little, I would think, my lord.
So, vanishing, I think, was the expression
Yes,
that
yes,
Lady Hill used.
I think very little.
Yes.
Yes. Now, there is, in my submission, no really room for debate that the second stage is an objective evaluation by the judge, really for four reasons. First, the words used in the statute cannot reasonably be expected provide an overarching objective test. There is room within the overarching objective test for the subjective analysis. The second reason is it is precisely because the behaviour fact does not necessarily denote fault or culpability on the part of the respondent that the presence of behaviour must be accompanied by an objectively evaluated additional requirement that the petitioner cannot reasonably be expected to live with the respondent as a result of his behaviour. Otherwise, the entirely innocent respondent is left underprotected by the law, and Parliament cannot have intended that consequence when divorce involves a change of status.
Aren't you slipping into fault-based language when you talk about the entirely innocent respondent? Mrs. Thurlow was entirely innocent, but you accept that Thurlow and Thurlow was correctly decided.
I was thinking there of Mrs. Pheasant.
Well, you may have been, but I'm still putting to you, I didn't know you were thinking of Mrs. Pheasant.
Yes. That's the innocent respondent, yes.
Well,
the third reason why it's an objective test is that if Parliament had intended a subjective test, it would have followed the wording in section 1.2a, the preceding adultery fact, which is clearly a subjective test. Inescapably subjective are the words used by Mr. Justice Ormerod in Pheasant. And under section 1.2a, the petitioner has to prove that the respondent has committed adultery, whether for this or any other reason, that he or she finds it intolerable to live with the respondent. And the wording in section 1.2a omits any objective value judgment by the court on whether it is reasonable for the petitioner to find it intolerable to live with the respondent.
I seem to recall that took a decision, didn't it?
It did, Cleary. Yes,
Cleary,
case of
yes.
Cleary, yes. There were two conflicting decisions, and then the Court of Appeal in Cleary, I think it was 1974, held that it was two separate factual situations that the court had to look at, adultery and whether the petitioner found it intolerable to live with the respondent. So having proved adultery, the petitioner only really has to say no more than she finds it intolerable to live with the respondent. And if the feeling of intolerability comes from the adultery itself, then she obviously, or he obviously, we would say, would have a very easy ride. And clearly what Parliament intended is a subjective test for the adultery fact and an objective test for the behaviour fact.
But a rather high test. Intolerability is higher than unreasonable.
Yes, it is. It is, but it's entirely subjective.
As was held in Cleary.
Yes, yes. And we've seen from the authorities that my learned friend has taken you to that all the authorities since the early 1970s all state that the test in section 1.2b is an objective one. And that view was also agreed by the law commissioners in the 1990 report. There is only one reported case in which the petitioner argued that it was a subjective test, and that's the case of Pheasant. And that argument was rejected, which I'll come to in a moment. Now, we have seen from the trial judge's judgment that he specifically applied the Livingston-Stallard test. He even went as far as to italicize the jury direction to himself. And it's also quite clear, as my Lord Mance pointed out, looking at the transcript, that the judge in his concluding paragraphs specifically said that he could find, sorry if I could just find that passage, it's the end of his judgment. He specifically says at page 221, I find no behaviour such that the wife cannot reasonably be expected to live with the husband. So he's directed himself to the correct test, he's emphasized it, and he concludes by saying he finds no such behavior. Now, he is not, we say, falling into a linguistic trap here. He's plainly following the direction that was laid down in Livingston-Stallard.
Might I raise with counsel a particular matter before the short adjournment?
By all means, it's a convenient moment at which to do.
Thank you. Mr. Dyer,
My Lord.
would you forgive my bringing up a new point?
Of course not, my Lord.
We all know that the behaviour necessary for Section 1(2)b does not have to be the cause of the breakdown of the marriage. Mr. Justice Sheldon said that in Stevens. Sir James Munby quoted that passage with approval in the judgment under appeal. You've conceded it in your written case, and you mentioned it half an hour ago. As I began work on preparation for this hearing yesterday, I became inquisitive about whether Judge Tolson had approached this case on the basis that he was looking for behaviour which caused the breakdown of the marriage. And I know you've got his judgment to hand. You've just been quoting it. I read it, obviously, from start to finish. And so I began with paragraph 1, if you've got that.
I have, my Lord.
The opening sentence. In this case, I must decide whether a 38-year-long marriage comes to an end as a result of the husband's unreasonable behaviour. And so I began to wonder, is he looking for the husband's behaviour causing the breakdown of the marriage? And then I read on, and I turned in particular to paragraph 7, overleaf, where the judge is dealing with the general complaint of the wife about prioritization of work commitments over home life.
Yes.
And 4 lines up from the bottom of paragraph 7, the judge writes, no complaint seems to have been made about this at the time. The idea that the lifestyle, whatever it may have been, now contributes to the breakdown of the marriage is fanciful. The ground is no more than a conventional form of words with no application to the present or the breakdown of the marriage at all. And so, Mr. Dyer, I wondered whether that was another possible pointer to the judge falling into the error which I have identified. And then would you be prepared to go back to paragraph 15, from which you have quoted only 3 minutes ago? 3rd line, I find no behaviour such that the wife cannot reasonably be expected to live with the husband. You read that out to us very kindly 3 minutes ago, but you didn't read the following sentence. The fact that she does not live with the husband has other causes. And so I sat back and said to myself, is this judge looking for behaviour which caused the fact that Mrs. Owens no longer lives with the husband? And then later on in my preparation for the case, of course, I looked at the skeleton argument which your able junior prepared for the judge's assistance. And if you've got that, of course, it's in Appendix 2, page 344. Memory stick. Have you got the last paragraph of Mr. Dunlop's skeleton?
Yes, I have.
Ultimately, if the court concluded that the marriage was at an end but not due to H's fault, it would be possible for the parties to reorganize their affairs. Well, let's put the reference to fault on one side. Not due to the husband's fault, not due to the husband's behavior. And so, at the end of it all, I asked myself, and this is my opportunity to ask you, whether perhaps there was a misapprehension in the mind of Judge Tolson when he determined this case. And insofar as there has been a suggestion today that there was, in various respects, major or minor, a degree of unfairness about the way in which this matter proceeded before the judge, we must not compound it in relation to any unfairness to you. This is a point that has never been raised. If Mr. Marshall doesn't take it, it's unlikely to be valid. If Sir James Munby doesn't take it, it may be unlikely to be valid. But forgive me, it still worries me. And so if you would be prepared, either at 2 o'clock or if you feel you can't do justice to the point, then perhaps in writing later, if you would be prepared to deal with it, I personally would find that very helpful.
Yes, certainly.
Well, that is a convenient moment.
Thank you.
Court is now adjourned.